In a recent legal ruling, the Polokwane High Court in South Africa has made a significant decision regarding the citizenship of children born in the country to foreign national parents. The court's verdict has clarified that children born to non-South African parents do not automatically acquire South African citizenship upon their birth in the country. This ruling has implications for foreign nationals living in South Africa who seek citizenship for their children born in the country. The case in question involved Zimbabwean parents who had applied for South African birth certificates for their 3 children, born between 2010 and 2016, a request that was ultimately denied by the Department of Home Affairs. The Zimbabwean parents, who were residing in South Africa on work and visitors permits, approached the Department of Home Affairs to request South African birth certificates for their children. They argued that since their children were born in South Africa and their parents held valid permits, their children should be entitled to South African citizenship. However, the Department of Home Affairs rejected their application, stating that citizenship could not be conferred on the children of permit holders for work, study, or holiday purposes. Instead, the department advised the parents to obtain unabridged birth certificates for non-South African citizens for their children, so they could then go to Zimbabwe to acquire Zimbabwean birth certificates. The parents contended that the department's refusal was unlawful, unconstitutional, and invalid, asserting that their children's birth in South Africa should automatically grant them South African citizenship. The Polokwane High Court's decision, delivered with careful consideration of South African citizenship laws, upheld the Department of Home Affairs' stance. The court emphasized the fundamental principle that a child's citizenship follows that of their parents. If one parent is a South African citizen, the child is deemed a citizen by birth. In this case, both parents were Zimbabwean citizens and had not renounced their citizenship. Dual citizenship is prohibited by South African law, which means that the parents' children remained Zimbabwean citizens. The court also noted that while the parents held permits to stay in South Africa, they had not taken the necessary steps to elevate their status to that of residents, making it doubtful whether they remained permit holders. This failure to regularize their stay in the country put their children's identity and nationality at risk, especially if their permits had expired. Furthermore, the court emphasized that South African citizenship is not merely a legal status, it goes to the core of a person's identity and their sense of belonging. Citizenship decisions should be made with utmost care, considering the individual's circumstances and the principles of the law. The Polokwane High Court's ruling in this case provides clarity on the issue of South African citizenship for children born to foreign national parents. It reaffirms the principle that a child's citizenship follows that of their parents, and underscores the importance of complying with South African immigration laws to protect children's identity and nationality. While this decision may be disappointing for the Zimbabwean parents involved, it highlights the significance of understanding and adhering to the citizenship laws of the host country. In this instance, the court determined that the parents' failure to regularize their stay in South Africa and their dual citizenship status made their children Zimbabwean citizens rather than South African citizens. The court's ruling underscores the complexity and sensitivity of citizenship issues and the need for individuals to navigate them diligently and in accordance with the law.